purchase the car from you.
Let me introduce you some choices.
This car is not bad. Yeah, it's so nice. I like it. Is it accident free?
Yes, of course.
Really?
Yes.
Does he have a duty to disclose? Huh?
Siapa punya telefon ni? Hi, I'm Wong Yinson.
Hi, I'm Zhi Yi.
I'm Yng Yiin. I'm Zhi Yi.
I'm Sia.
Please
enjoy
enjoy
our
our video.
The given statement proposes that under the law of contract in England and Wales and also in Malaysia, parties to a contract are generally not under the legal obligation to ensure the opposing party are fully informed as to any aspect of the transactions. Hence, it's safe to infer that in this jurisdiction, it's tried law that there's no duty to disclose anything to the other side in a contract. Hence, mere silence does not constitute any misrepresentation as clearly entrenched in the case of Keats and Cadogan. The perception of misrepresentation is denoted as an unambiguous false statement of fact or law which is addressed to the other party misled when negotiation is being carried out, and it has to be material and which induces the other party to enter into the contract. Following the case of Shogun Finance Limited and Hudson, it was decided once this transpires, the law automatically deems that there is no free consent, hence rendering the contract voidable, subsequently giving the innocent party the right to rescind the contract and or claim damages. A logical inference that can be drawn from the very definition of misrepresentation and its nature is that an action of misrepresentation can be pursued only if a false statement was made, hence clearly excluding silence as giving rise to actionable misrepresentation. The above notion pertaining to non-disclosure is said to conform to the fundamental doctrine of freedom of contract, where it is recognized that party in a contract have the discretion and the freedom to choose what they want to disclose and not to disclose to the other party during the contractual negotiation. However, a closer scrutiny in this realm of contract law would go on to reveal that the above is not an absolute rule, as there exists a number of common law exceptions where the general rule of no duty to disclose would be displaced and the representative would be imposed a duty to disclose. If the said case fall within the ambit of one of these exceptions, when does the law impose such a duty on the party to disclose the material fact would be discussed accordingly by my fellow teammates who would firstly indulge in the detailed discussion on the circumstances when silent or non-disclosure would actually give rise to actionable misrepresentation in law. This discussion would proceed by a comparison with the position under Malaysian law. Following this, an in-depth analysis of the possible reform that would suit the needs of this area of law would be discussed in great depth.
First of all, according to the principle applied in Gordon and Selifor, silence or non-disclosure will not amount to a statement which implies that the representative carries no obligation to disclose material facts known to himself, but not the others including the contracting representative during the course of negotiation, leading to the formation of a contract. Along these lines, for the most part, silence does not amount to a misrepresentation. The rationale behind this general rule is provided by the ancient law and contract, where he claimed that, due to reality, the fact that if a positive duty is imposed, it will be excessively oppressive upon the contractor and this might hinder commercial activities. Furthermore, Adams and Bronsworth proposed that the non-disclosure merely reflects the reality of commercial practice and freedom of contracts. Likewise, the minimalized regulation towards commercial transactions in order to mirror the contractual intention of parties. This is the view in line with the laissez-faire theory and caveat emptor, which intended let the buyer beware. For example, in Bradford Third Equitable Benefit Building Societies and Borders, the court held that mere silence, however morally wrong, will not support an action of deceit. However, if the information has been asked for, then there is a duty to disclose the truth. Plain from the facts presented, something more than silence is necessary to amount to misrepresentation. But there as it may, there are several situations where the law imposes a duty to disclose information by the dealer. Inability to do so may be subjected to a misrepresentation. Such occurrences where there is a need to disclose information is where the contracts are made in good faith, which also known as Uberime Fidei, such as insurance contracts. It is believed that despite the fact that this approach does indeed sacrifice the freedom of contract, it encourages trustworthiness in insurance contracts, which is a quintessential element of Uberime Fidei. A misleading half-truth may amount to a misrepresentation too. In Nottingham Pen and Brick and Tile Company and Brattle, a misleading half-truth is a true statement which is confusing and deceptive at the same time due to all relevant information not being revealed. Besides, as stated in the case of Pitt and Gurney, partial non-disclosure may amount to a misrepresentation because of a half a truth will sometimes amount to a real falsehood, which is also a positive misrepresentation. Additionally, suppression of material facts can render a true statement false and amount to misrepresentation, as demonstrated in Dimmock and Heller, where the seller of the land told a prospective buyer that his units was rented out, but did not mention that the tenants were about to leave soon. Consequently, the purchaser has to find tenants immediately after the completion of the purchase. With that, the court held that suppression of the material facts can be amount to the misrepresentation, and rescissions were allowed. This illustrated that even though the seller is really obliged to disclose the material facts during the negotiation, but if he suppresses the material facts, it can still render a true statement false and amount to misrepresentation. According to the case of With or Flanagan, if a statement is made which is true at the time of market but subsequently becomes untrue, there is a positive duty on the representative to ensure that relevant party is informed about this. In the mentioned case, the doctor told a prospective buyer that his medical practice was worth £200 per annum, but later, when he fell ill and neglected his practice value amounts to nothing. The court ruled that by failing to notify the buyer regarding the current status before coming to the conclusion of the contract constitute a misrepresentation. Moreover, the case of Davis and London and Provincial Marine Insurance had held that even in situations where there is only a half-truth representation, there is an obligation to disclose to the other party with regards to the change in circumstances. It is submitted that there is a duty to disclose information where there has been a substantial difference in circumstance. On the other side of the coin, there is also a duty to inform and not remain silent where both parties have established a fiduciary relationship, such as solicitor-client or a doctor-patient relationship. The reasonable argument behind this duty to inform is such that the relationship is, in fact, standing in a position of mutual trust, confidence, and understanding, which require the party to act in the best interest for those whom the duty was owed. According to the case of Allengers and New Sombrero Prospect Company, a fiduciary must not make a secret profit. It is shown beyond doubt that such disclosure is pivotal to maintain trust and to avoid a possible conflict of interest. In a nutshell, it is true that the representative is not obliged to disclose all material facts during the negotiation, which equates to declare that silence does not amount to an actionable misrepresentation. However, there are exceptions and situations as discussed above whereby there is a duty to speak and not remain silent when silence may be an inducing factor for the representative to enter into a contract.
In contrast with the English law, when we look in the Malaysian's position on fraud and silence, in most of the time we look at the Contracts Act 1950, which is the principal legislation governing contracts in Malaysia and is one that we perceive as a codification of English common law and rules of equity concerning the formation of contracts. So there is a lot of similarities with the English law, but some differences can still exist. Speaking of fraud, the main provision is that of Section 17 of the Contracts Act 1950. It provides that the act of fraud happens when a party or its agents has done one of the acts covered under this section. For clarifications, Section 70 sub A is that of a suggestion as to a fact which the party knows that it is not true. This can be observed in the Malaysian case of Kang Tri Lian and Wong Tak Tong, where Wong was induced by fraudulent misrepresentation to enter second agreement, whereas Section 17B is the concealment of a fact by the party with knowledge, normally cited with the case of Segar Oil Palm Estate, which was held by the courts to be a fraud as Segar actively concealed a fact relevant in the case when they were aware of the object. And Section 70C states that a fraud is when a party made a promise without the intention of performing it, just as it was held in Para Rajaratnam and Dato' Jaginder Singh and others, where the defendants had no intention to transfer the land as promised. These three acts covered the common law of fraudulent misrepresentation as defined by the House of Lords in the case of Dairy and Pig. Now, under Section 70D, any other act fitted to deceive, and Section 70E that states that any omissions declared by law to be fraudulent further widen the law for fraudulent in Malaysia as compared to the English common law. Section 70 in its explanation further explains that the silence of a contracting party from the disclosure of certain factual information does not make the fact a fraud. This section provided an obvious and easy to understand illustration which gives that where A sold an unsound horse to B in an auction and A does not disclose the fact that the horse is unsound, this is mere silence and not considered as fraud under the Malaysian contract law. This principle can be proven in the case of Lau Ti Tia and Harjil Engineering Sendirian Berhad and another, where the federal court ruled that the owner of the vehicle had no activity duty to inform all information of the vehicle to the buyer even there are defects. However, things can be different if the relation of the buyer and seller are close. For example, the relationship of father and daughter. In this circumstance, under illustration B, there is a duty to reveal every piece of fact to the buyer by the seller, even if there are defects in the goods. This is comparable with the fiduciary relationship between two parties known as the principle of uberrime fide, which is also found in common law case of Bell and Liver Brothers Limited that held contracts of good faith. Facts must be disclosed. So, mere silence is not fraud even if the facts are likely to change the mind and willingness of the other party entering a contract. This follows the English common law principles as that in Bradford Perth Equitable Benefit Building Society and Borders. This was illustrated in Malaysian Contract Act 1950 Section 17, illustration A, or in another circumstances illustration D, where both parties being traders, another party with private info has no duty to inform the other party about a price change that potentially affect his willingness to proceed with the contract, unless in some cases the person has a duty to speak. If not, his silence will amount to speech. This is illustrated in illustration C, where B tells A that if A does not deny it, B shall assume that the horse is sound. Now, if A remains silent, his silence is equivalent to speech, and let us say that the horse is in fact unsound, then A is concealing a fact and therefore a fraud. Another similarity with the English common law is found in the exception part of Section 19 of Contracts Act 1950. The exception is a consent was caused by whatever kind of fraudulent under the Section 17 is not voidable if the party who gave consent had the means of seeking the truth with the degree of carefulness as a normal man would give. This exception puts the duty onto the buyer to check the goods himself and not to rely 100% on the words of the seller. This concept is the same in common law, which is known as caveat emptor, which literally means let the buyer beware. This further supports the statement where Malaysia, together with England and Wales, does not impose a duty to disclose material facts in the formation of contract. To round this up, it is suggested by legislation that in Malaysian law, as similar to the English law, that there is no general duty of disclosure. They are mainly backed up by the explanation to Section 17 of the Contracts Act 1950, since it is known that this piece of legislation is the codified version of the common law.
Gleaned from the foregoing discussion above, it cannot be denied that the English contract law position regarding to the duty to disclose has been subjected to various arguments than the issues and countervailing perspective which this legal position encapsulates had not been unambiguously resolved in the court. In this matter of contention, the Borden court have appeared to be entirely unconscious to the doubt, as well as criticism in this area, leading to the rise of various problems. For this reason, prompt action has to be taken in order to reform the law for the sake of justice as well as fairness. One of the most hotly debated questions under the English contract law is under what circumstances an individual has a duty to disclose relevant information unknown to the other contracting party. It has always been contended that due to the absence of a fiduciary or confidential relationship, an individual is never under a duty to disclose all that he knows or she knows to the other party. Instead, the imposition of disclosure duties should depend on the type of information as well as the circumstances in question. The law should be reformed in a manner where an informed party should be under a duty to disclose to the uninformed party when the information is intrinsic in nature, in relation to later defects, as well as a defect which is likely to cause bodily injury or property damage. For instance, tobacco companies should be under a duty to disclose the health risks associated with cigarette smoking, and also the obligation on the sellers of real property to disclose the presence of asbestos or lead paint. Failure to disclose this information would give rise to liability, where the innocent party would be entitled to rescind the contract. At the same time, in the light of the case with and of Flanagan, there is the duty to disclose a change in circumstances which render a statement which, when made is true or believed to be true, but which subsequently, before the contract is concluded and acted upon, to the knowledge of the maker, becomes or is discovered to be false. While this may be true, what follows if the representative was not, at the time of contract formation, in any sense aware of the changed circumstances, rendering the accuracy of his original statement? In the wake of this case, it can be seen that the court were merely directed to the specific facts where it was clear that the change was known and thereby there is no express statement dealing with unknown change. Consequently, it might be concluded that there is no right or liability to rescission when the change is unknown, as there is no duty of disclosure under English common law in respect of unknown material facts. As a matter of fact, the English law should make a clear stand regarding this issue and adopt the best approach which achieve consistency with the principle traditionally embedded relating to duty to disclose. The law should be reformed in a way that if a representation has been falsified without the maker's knowledge before the conclusion of the contract, the maker should be liable as for innocent misrepresentation, and the innocent party should be entitled to a rescission of a particular contract. The duty to communicate approach should be adopted in such a case as it is the imperative duty of the party who has made the representation to communicate to the party to whom the representation has been made the alteration of those circumstances. The defendant should be under a duty to modify the term or withdraw the inaccurate information contained in his original statement which created a false impression on the innocent party. Section 1, 2, and 3 of the Misrepresentation Act 1967 uses the expression misrepresentation made, which seems to refer to active misrepresentation as to cover the issue of non-disclosure. As a result of this, the Act does not impose liability for non-disclosure of material fact, nor does the Act vary any existing liability or defense based on non-disclosure. Consequently, various cases in relation to non-disclosure were severely affected by the Act, rendering the innocent party rights to rescind the contract where there is non-disclosure of a particular information by the party who made the representation.
draw an analogy between different jurisdictions other than the United Kingdom and Malaysia, which is the Islamic law in this context, studied from an academic point of view, as well as of practical import for legal reform. While common law generally does not treat silence as an actionable misrepresentation, in Islamic law, silence does not constitute an affirmative bill. The repercussion for this distinction is that when future disputes arise, the party in Islamic law reserve the option to rescind a contract, whereby such an opportunity is not affordable in common law. Of the various kinds of misrepresentation, fraudulence, negligence, and innocence are most regularly known, and all the common practices had omitted silence as a nullifying factor. Although in some jurisdictions, such as Malaysia and several Commonwealth countries, silence is considered as misrepresentation in contract. Silence as non-representation has been playing a controversial role in different disputes throughout the years. As little as 3 exceptions developed in common law regarding silence as misrepresentation, the jurisprudential practices are critiqued as vague, ambiguous, and insufficient. In Islamic legal traditions, a contract is concluded on the basis of the mutual acceptance of both parties, and the general Islamic principle is that no statement is attributable to a silent person. Hence, with compliance to the Islamic law principle, a seller in a contract must disclose everything about his goods, especially about the defect of his goods. Deriving from the verbatim terms in Islamic law, tadlis carries a meaning closest to misrepresentation. It is defined as a dishonest and deliberate action of one party leading to erroneous judgment of another party who eventually enters into contract. Tagrir is broad in a sense to encompass misleading measures via word action or words or absence of either, leading to a transaction that would not have otherwise occurred. Contrarily, in common law, there are only 3 sets of circumstances in which silence or non-disclosure can be a relief for the plaintiff. First, if silence misstated a positive representation. Secondly, if the contract demands will remain fide. And third, if a fiduciary relationship is present. Analyzing Islamic law standing in contract, justice, morality, humanity, equity, and fairness are vital in the list of goals of Sharia. Thus, Islamic law has indeed adopted a contractual obligation that differs with the subjective English common law theories. Nevertheless, as a matter of fact, Islamic law recognizes that mere action of silence does not form tadlis, and the intention of concealment must also be proved by the plaintiff, which subsequently influenced him entering the contract. Islamic law applies this doctrine of failure of disclosure into 2 circumstances. The first involves a non-disclosure of the subject of sale by the representative and is known as a fraud with defect in the bargain. The second situation arises when there is a betrayal of trust relations, similar to the exception of the fiduciary relationship in common law. Thus, it is apparent that the common law practice follow a set of strict rules depending on legal doctrines and precedents. But on the other hand, Islamic law on contracts emphasizes to bring equity among the contractual parties. By borrowing principles from the Islamic tradition, it can easily be compared and adopted by the common law system to facilitate justice and equity among its own jurisdiction, as the Islamic law principles regarding silence are more definitive and lucid. The fine-tuning practice to look into the matters in greater details is fairer in terms of avoiding future possibility of disputes, minimizing arbitrariness, and contributing to the unification of international trade and customs exercise. Furthermore, the attention has focused on whether a distinction can or should be made between active reception and non-disclosure. To date, tenuous attention has been drawn to this distinction, or non-disclosure has simply been freedom of the party when constructing a contract as a general rule. On the rare occasion where the distinction has been recognized as potentially morally irrelevant, and any settlement in legal term has been rejected. In Canada, the Supreme Court had recognized that the adoption of such distinction would be useful to tackling the issue of uncertainty and precluding those who negligently or inadvertently failed to disclose certain material facts. However, they ultimately rejected the idea that there was a principle and clear-cut distinction between active and passive deceit, stating that fraud is fraud, whether induced by blatant lie or sly deceit. The hassle and struggle to distinguish between active fraud and passively misleading by non-disclosure are inevitable. Nonetheless, a straightforward fact was accepted in the public realm that active deception evidences a more culpable state of mind when compared to the later. When in cases of non-disclosure, the representative had offered no warranty, and it could be argued that the representee, by failing to make inquiries before entering the contract or by making own assumptions, bears a responsibility that cannot be shirked. Therefore, despite the complexity of attempting to distinguish between active fraud and non-disclosure, It is being argued in light of reasonable ground upon which such a distinction can be justified, that the courts should strive to develop a coherent concept of deception. Such a concept should extend somewhat beyond abstract lies so as to include deceptive dismissal or misleading statement of acts, with exceptional care taken not to overstretch the concept to the point of analytical collapse.
At the end of the day, it's safe to draw a conclusion that common law threat in the opposed embraced by the law of contract in England and Wales and that of in Malaysia would be the fact that none of these jurisdictions impose a general duty on contracting parties to disclose material fact that is exclusively known to one contracting party but not to the other during the course of negotiation leading to the formation of a contract. This inevitably means silence cannot amount to actionable misrepresentation. The reason for this is most likely the fear of opening up the floodgate of litigation, which in the long run may undermine the fundamental principle of freedom of contract, which form the cornerstone of contract law. However, it's evident that over the years, the court has found inroads into the rule of silence and accordingly attempt to correct the disparity of knowledge between the bargaining parties. Sadly, determining the exact circumstances, the court may interject remain inconsistent and uncertain as till date. This common law exception has not been given clearly statutory footing. To make matters worse, the court has seemingly embraced divergent rules in similar or identical cases and have failed to articulate a coherent or consistent rule as to when they would impose a duty of disclosure on the contracting parties. Due to this inconsistency, it's revealed that the time is clearly ripe for this jurisdiction to adopt legislative reform to inject the much needed clarity in this area of law. The said legislative reform would also be clearly laid down the specific instances when the court ought to impose a duty not to be silent. This will act as an excellent guideline for judges when dealing with complex cases. Furthermore, by only giving the exception to the rule of silence, a statutory footing, it is evident that the fundamental doctrine of freedom of contract would be greatly preserved. Therefore, with the discussion on the possible reform in this area of law, even inclusive of circumstances where both parties are unaware of the changes in material fact, the duty to disclose of material fact by contracting party will develop in a more desirable manner.
Thank you for watching.